Picture this. This is my second marriage. I have adult children that I want to provide for in my will. However, with my current spouse or soon to be spouse, I'm not ready to put them in my will. What should I do? Hi, everyone. My name is Leah Boston. I'm an estate planning attorney here in the state of Maryland and owner of Law Office of Leah Boston, LLC. I draft wills, trusts, and I talk about long-term life care planning with people like you. This is a common scenario for individuals that get remarried later in life that have adult children they want to ensure are provided for in their estate plan, and they may not necessarily be ready to allow their current spouse to take more than what they essentially want them to have. So it's really important to understand what the dynamics are when you do get remarried and why it's important to plan ahead of time if you have any sort of worries or you have any opinions about what you believe your spouse should have. I do want to talk about something called the elective share. So I'm licensed to practice law in the state of Maryland. So my discussion on this topic will be coming from the standpoint of Maryland law and Maryland law only. Elective share essentially is kind of like a quote unquote foolproof plan here in the state of Maryland that allows a surviving spouse to not be completely disinherited from the deceased spouse's estate. It allows them to claim a portion of the estate that the deceased spouse has left. The formula in which the surviving spouse can take from the deceased spouse's estate is going to depend on whether there are any surviving children, descendants, or if there's not any surviving descendants. I believe in the state of Maryland, it's 1/3 of the augmented estate if the individual has surviving descendants, and then 1/2 of the estate if there are no surviving descendants. So the question is, can you disinherit a spouse? Well, that actually depends, because the elective share is absolute, and the only time that the elective share will not technically come into play is if the surviving spouse waives it, either in a postnuptial or prenuptial agreement, or the spouse does not actively pursue it. And what I mean by actively pursue is the right to the elective share is not automatic. This is something that the surviving spouse has to let the personal representative know. And I believe there's a time limit. I believe it's 9 months from the date of death of the passed away spouse, and then 6 months or 6 months when the personal representative of the deceased spouse is named to the estate. So essentially, there are a couple of moving factors here. Can you completely disinherit your spouse from your estate plan? Not necessarily so, unless this is something that you and your spouse have agreed upon in a pre or postnuptial type of agreement where the surviving spouse will have waived their ability to take in the elective share. Then this is something where the surviving spouse can say, you know what, I've waived my right to take anything from my deceased spouse's estate. Read the will or do the trust, etc., read it as it may, and I'm just going to leave it alone. Or if you have provided for your spouse in your estate plan and your current surviving spouse does not believe that it is enough or that they are satisfied with that, they do have the ability in writing to let the personal representative know, hey, I'm not satisfied with this, so I'm going to exercise my right to the elective share of my deceased spouse's estate and take from that. It is kind of a convoluted type of situation where there are a lot of moving pieces. In actuality, can you completely disinherit your spouse? I'd say the best way to disinherit your spouse is to have a conversation with your spouse and say, hey, I really want to leave my assets to my adult children. This is a marriage that's happened later in life, and I want to ensure that my children, grandchildren, etc., my parents or my siblings are taken care of. Let's waive this right, etc. It's really important to have conversations, because if this is something that you feel strongly about, definitely discuss it with an estate planning attorney. If you're here in the state of Maryland, please contact my office, and this is something that we can talk about. However, if you don't plan, and if this is something that you definitely feel strongly about, your spouse may be able to take either 1/3 or 1/2 of your estate if they are not satisfied with what it was left to them in the estate plan. All in all, can you disinherit your spouse? Yes, no, but there are a lot of moving parts and something that needs to be discussed beforehand. If you have any questions or would like me to go into deeper detail about what the elective share is, how it can be used for surviving spouses, and kind of like what that postnuptial or prenuptial agreement should look like if you're in the state of Maryland, please contact my office. I can be reached at www.leahbostonlaw.com, and I will see you in the next video. Bye.